Imagine walking outside, pointing at a bird flying across the sky, and telling your neighbor, hey, you can't use the concept of things moving through the air. Like, I own that.
Yeah, you sound completely ridiculous.
Right. Because basic geometry, the fundamental physics of motion, these are the basic building blocks of reality. They belong to everyone. But as we're going to see in today's deep dive, my fellow learners, this exact scenario is actually playing out right now in the AI sector.
It really is, and it's wild.
It is wild. What happens when you take those basic building blocks like an angular shape or a specific way a line animates across a screen and you just drop them into the most lucrative, hyper-competitive technology boom in human history? Suddenly, those basic shapes aren't just shapes anymore. They are, prime real estate.
Oh, absolutely. They become heavily fortified intellectual property,
Yeah.
and the walls going up around that property are getting higher by the day. Plus, the methods used to defend them are just becoming much, much more aggressive.
Which is pretty scary for anyone entering the space.
Definitely. We are seeing this massive shift from protecting specific, intricate logos to trying to fence off entire categories of, well, visual feeling and motion.
Which is exactly why we are unpacking this today. To all of you learners out there, whether you are an entrepreneur sketching out your first startup logo, a designer trying to capture the feeling of the future, or just someone who is insanely curious about how power really works in the tech industry, this one is a fascinating look into a high-stakes turf war.
It's a massive battle over trust, visual identity, and, yeah, basic geometry.
And we've got an incredible stack of sources today to figure it all out. We are pulling from some deep legal analysis of a newly filed trademark dispute. We have actual docket metadata from the Northern District of California, specifically case number 3.26CV06754, filed on July 1st, 2026.
A very recent drop.
Super recent. And we also have the highly strategic public statements from the executives who are caught right in the crossfire. So what's our mission today? We need to pull apart this specific lawsuit between Anthropic, which is obviously one of the leading frontier AI labs, and Abnormal AI, a massive cybersecurity company.
Right, and we really need to discover whether a single AI company can legally own the basic visual grammar of the entire industry.
Yeah.
And perhaps even more importantly, we are looking at the ecosystem dynamics. Like, what actually happens when a self-proclaimed safety-first AI lab decides to sue one of its most lucrative loyal customers over the very way their brand looks and moves?
Okay, let's unpack this. Because the sheer scale of what Anthropic is asking for here is it's mind-blowing. They are suing Abnormal AI under the Lanham Act.
Right.
And the specific claims are for trademark infringement, unfair competition, and false designation of origin. The whole center of the dispute is this angular slash-based A mark. But, it's the remedy Anthropic is seeking that genuinely made my jaw drop when I was reading through the sources.
Yeah, they are not messing around.
Not at all. They aren't just asking Abnormal to change their logo. They aren't asking for a standard licensing fee or, I don't know, a slap on the wrist. Anthropic is seeking the disgorgement of all revenues, earnings, profits, compensation, and benefits from Abnormal. All of it.
It's a huge demand.
To me, that feels like demanding the deed to someone's entire house just because they painted their front door a similar shade of blue to yours. Like, is this a standard legal maneuver, or is this an incredibly aggressive nuclear strike?
Well, the historical context here makes this maneuver incredibly aggressive. So think of the Lanham Act as the ultimate referee for brand identity.
Right.
It was originally designed way back in the 1940s.
Oh, wow, so it's quite old.
And the core intent back then was consumer protection. It was built to stop snake oil salesmen from, slapping a Coca-Cola label on a bottle of brown water and tricking you into buying it.
Right, protecting against actual fake goods.
Exactly. It was built for physical goods and clear, tangible deception. But now it's being stretched to cover these abstract, geometric AI software logos. And while the Lanham Act does allow a prevailing plaintiff to recover a defendant's profits, the mechanism of disgorgement is just brutal.
How does that actually work in practice?
So, in standard litigation, the plaintiff has to prove exactly how much money they lost. But in disgorgement, the plaintiff just points to the defendant's gross sales. That's it.
Wait, really?
Yeah. And then the burden completely shifts to the defendant. They have to prove which of their costs should be deducted, and more importantly, they have to mathematically prove which of those profits were not derived from the allegedly infringing logo.
Wait. So if Abnormal makes $100 million selling complex cybersecurity software, Anthropic can just say, give us the $100 million, And Abnormal has to somehow mathematically prove that their customers bought the software for the actual cybersecurity AI and not because they were just like mesmerized by the Angular A logo.
That is the exact accounting nightmare this creates. It is basically a bet the company threat.
That is insane.
It is. But there is a crucial safeguard here. This recovery is entirely subject to what the courts call the principles of equity. It's not just an automatic payout because you win the trademark claim.
Okay, so the judge steps in.
Right. A judge has to look at the totality of the circumstances and decide if bankrupting or gutting a company over an abstract mark is fundamentally fair and just.
Which I imagine is a pretty high bar.
A massive bar. To convince a court that handing over an entire enterprise's economics is equitable, Anthropic needs a remarkably strong fact pattern. They have to prove that Abnormal didn't just, stumble into a similar design. They have to show that this abstract logo is deeply deceptive to the market and so maliciously copied that equity literally demands total financial ruin.
So if you are dropping a company threatening demands like that on the table, you'd assume Anthropic has a slam dunk open and shut case. You'd think they caught Abnormal hacking into their design servers and ripping off their logo yesterday.
You would think so, yeah.
But when you actually lay out the tutting line of who designed what and when, the narrative gets incredibly complicated.
Let's actually examine Abnormal's chronological defense here, because they have laid it out very publicly for everyone to see. Abnormal's CEO, Evan Reiser, claims the company was actually founded back in 2018.
Right.
And then they went out and hired a design firm called Align in April 2021 to completely overhaul their visual identity.
And we have hard external proof of this. It's not just the CEO doing, damage control on social media. The sources point to a feature in a design publication called Transform magazine, dated November 15th, 2021.
Exactly, a public, time-stamped record.
Yes, and this article documents Align's exact work for what was then called Abnormal Security. The article shows their old generic blue brain and circuit icon being tossed out, and in its place, Align custom designed a word mark and injected a symbol using a triangular outline and acute points. It is literally a pixel-for-pixel match for the static logo Abnormal uses today.
And the dates here are just the most critical piece of evidence.
Yeah.
Because Anthropic, the plaintiff, was also founded in 2021.
Wow.
So Abnormal is aggressively pointing to this timeline to establish independent creation. They are essentially asking the public, and eventually a judge, how they could possibly have stolen Anthropic's brand identity when they were publicly launching this exact static design in a magazine at essentially the exact same time Anthropic was incorporating as a business.
That is a very strong defense.
Right. If the lawsuit was just about the static logo, that 2021 magazine article would likely stop Anthropic's case dead in its tracks.
But here's where it gets really interesting, though, because when you dig into the updated docket metadata, you see Anthropic's true, broader theory. They aren't just suing over that static logo from 2021.
Right, they've expanded the scope.
Yeah, they allege that during an April 2025 rebrand, when Abnormal Security changed its name to Abnormal AI, Abnormal didn't just keep the old logo. Anthropic claims Abnormal copied animated Anthropic motions, specific spatial arrangements, and visual proportions.
That's the core of their argument now.
And I have to push back on this logic. I mean, if Abnormal has irrefutably owned and used this static Angular A logo since 2021, how can Anthropic claim trademark infringement 4 years later in 2025? Like, can you really sue someone over the vibe and the motion of a shape they already legally used for years?
So the concept at play here is called brand system convergence, and it's a fascinating frontier in intellectual property. You see, you can absolutely protect non-traditional elements of a brand under what's called trade dress, or as motion marks.
Oh, like a sound or a color.
Exactly.
Yeah.
Think of the specific magenta color of T-Mobile, or that exact Totem sound and animation when you open Netflix.
Right, right.
Anthropic is arguing that Abnormal adopted a holistic visual identity system. The allegation is that at the exact moment Abnormal leaned harder into the AI market identity with their 2025 name change, they synced the behavior of their brand to Anthropic's. To use an analogy, it's like someone legally changing their first name to match yours, starting to dress exactly like you, buying the exact same car as you, and then moving into the house next door. Singly, none of those actions are illegal, but together they paint a picture of deliberate systemic impersonation.
Okay, so they are saying it's not the shape itself, it's how the shape behaves in the wild.
Precisely, and Anthropic adds a pretty serious layer of alleged intent to this. They point out that Abnormal executed this 2025 rebrand having had actual knowledge of Anthropic's specific branding.
Because they were customers, right?
Yes, Abnormal had been a paying Anthropic customer since at least January 2025.
Yeah.
So Anthropic's argument is that Abnormal was inside their ecosystem, saw how the Anthropic brand moves, breeds, and scales, and deliberately copied that motion language to make Abnormal AI feel like a frontier AI lab.
Wow. Okay, so it's the combination of the name change, the animation style, and that insider ecosystem knowledge. I see how that definitely shifts the narrative from a weird coincidence to an alleged coordinated strategy.
It builds a much more complex case.
It does. But all of this talk about visual systems and house next door impersonation is only relevant if it actually impacts the neighborhood, right? Which leads us to the core battlefield of this whole dispute the enterprise market. Because in a trademark infringement case, it doesn't matter how similar the animations are in a vacuum. You have to actually prove that real buyers with open wallets are getting confused.
Absolutely. The entire foundation of trademark law relies on buyer cognition. The law doesn't protect logos just for the sake of art. It protects consumers from deception. So we have to rigorously examine who these consumers actually are in this case.
And they are everyday shoppers.
Not at all. Abnormal uses behavioral AI for autonomous cyber defense. This isn't a $5 a month consumer app. They serve over 25% of the Fortune 500.
Huge enterprise deals.
Yes. And on the other side, Anthropic is famous for general AI models like Claude, but they also sell heavily into enterprise workflows. They even explicitly list security in the solutions taxonomy on their website.
And the sources even highlight that Abnormal publicly benchmarks its own product against Anthropic's Claude Opus variants. So they are absolutely playing in the exact same sandbox.
Except they are targeting the same spheres.
Anthropic is alleging that they share audiences, they sponsor the same conferences, and they are competing for the same enterprise IT budgets. But Abnormal's CEO, Evan Reiser, has stated unequivocally that no customer has ever bought their product thinking they were actually buying from Anthropic.
Which is a bold claim, but a crucial one.
And frankly, I have to challenge the core premise of Anthropic's lawsuit here. Are we really supposed to believe a Fortune 500 chief information security officer is going to accidentally purchase a multi-million-dollar autonomous security platform because they got hypnotized by a bouncing Angular A?
It sounds absurd when you put it like that.
I mean, this isn't like accidentally grabbing the wrong brand of Frosted Flakes at the grocery store just because the box was a similar shade of blue.
What's fascinating here is how the legal framework actually treats different types of buyers. You are intuitively touching on a massive hurdle for Anthropic. When a Fortune 500 CISO buys a cybersecurity platform, it is definitely not an impulse purchase.
Right. It takes months.
Exactly. There are typically 6 to 9 months of rigorous procurement cycles. There are deep technical security reviews, red teaming, vendor risk management compliance, integration planning, and board-level sign-offs.
A mountain of paperwork.
A literal mountain. And in trademark law, courts recognize this. It is exceptionally difficult to prove that highly informed, meticulous buyers undergoing that kind of extreme scrutiny were somehow deceived by an aesthetic similarity in a logo animation.
Because they literally have entire teams of specialized lawyers, engineers, and accountants vetting every single line item of that purchase before the check is cut. They know exactly who they are wiring millions of dollars to.
Exactly. Furthermore, if you look at the currently visible public record, there is a glaring absence of evidence for what the law calls actual confusion.
What does that usually look like?
Well, in strong trademark cases, plaintiffs bring forward public logs of misdirected customer support inquiries, documented lost deals where a buyer went to the competitor by mistake, or rigorous survey data proving market deception. Anthropic might possess some of this behind closed doors, but currently, their claim relies heavily on the inference of confusion.
Just assuming they are confused.
Right. And in the B2B enterprise software space, inferring confusion without hard evidence of a deceived procurement team is a very, very weak legal position.
And because proving actual confusion among Fortune 500 companies is such a monumental hurdle, we are seeing this dispute rapidly spill out of the courtroom and into the court of public opinion.
Oh, absolutely.
The PR and optics strategies here are honestly just as fascinating as the legal maneuvers. Both sides are deploying heavy artillery, but they are fighting completely different kinds of wars.
The contrast in their public postures is striking. Just consider how Abnormal's CEO handled the initial public disclosure. In a public post on July 7th, Evan Reiser noted that he actually learned of the lawsuit from a reporter reaching out for comment. rather than from Anthropic directly.
Let's just pause on that for a second, because that is wild. Abnormal isn't just some random scrappy startup in a garage. They are a massive, high-paying customer of Anthropic. Reiser disclosed that his personal account spends roughly $1 million a year, and Abnormal's company-wide spend is over $10 million annually.
It's a huge account.
Massive. They have rolled out Anthropic's Claude model to 100% of their employees. Have you ever seen a B2B company launch a bet the company lawsuit against an 8-figure customer without even picking up the phone first?
It is remarkably rare. Suing a customer of that magnitude, especially one that acts as a major distribution node for your core technology, it just defies standard B2B relationship management. Usually, a vendor would bend over backwards to resolve an IP dispute privately with a $10 million client. And Reiser knows how absurd this looks, and he uses that fact very deliberately in his public communications. He engages in what we might call reputational jujitsu. He mirrors Anthropic's own public benefit mission against them.
Oh, that's clever.
Very. Anthropic famously positions itself as a safety-first public benefit corporation, a company whose stated mission is to act for the global good. So Reiser essentially adopts the tone of a disappointed partner. He closes his public statement by saying he hopes the matter can be resolved quickly so both companies can return to their missions to act for the global good.
So what does this all mean? To me, it looks like Abnormal is basically holding up their hands to the broader tech community and saying, look at us, we're your biggest fan, we spend tens of millions of dollars with you, we are a vital, integrated part of your ecosystem, why are you trying to crush us?
Yes, that's the exact message.
And Anthropic's response to that ecosystem plea isn't a friendly Zoom call to hash it out. They responded by dropping in a legal SEAL Team 6.
That's a great way to put it. Anthropic's choice of counsel sends a very specific, aggressive message. They hired Morrison and Forster, widely known in the industry as MoFo, and brought in Daryl Dury.
Who's a major player, right?
She is a top-tier IP trial lawyer, highly renowned for complex intellectual property litigation in the tech and life sciences sectors. This is a massive signal to the broader market. You don't hire Daryl Dury to draft a polite cease and desist letter or to negotiate a quiet licensing fee.
Definitely not.
You hire her when you are preparing for a major, protracted, high-stakes jury trial over complex intellectual property.
They are out for blood. Or, at the very least, they are aiming for complete, undisputed market dominance over this specific visual space in the AI sector.
If we connect this to the bigger picture, you can see the paradox Anthropic has created for itself. By bringing in high-end trial counsel to strictly and aggressively enforce their market boundary, they are actively risking their carefully cultivated, responsible AI and safety-first public trust capital.
Which is their whole brand.
Right. They have spent years telling the public and regulators that they are the ethical stewards of the AI frontier. But punishing a major ecosystem contributor turns this lawsuit into a very public test of Anthropic's consistency and values. Reiser's PR strategy forces the enterprise market to ask a difficult question. Does Anthropic actually care more about the global good, or are they more interested in fiercely policing their brand turf against their own partners?
It's a brilliant countermove by Abnormal. They aren't just fighting the trademark claim on the legal merits of the Lanham Act. They are weaponizing Anthropic's own moral vocabulary against them.
It's extremely effective.
It makes a quiet, private settlement incredibly expensive for both sides, symbolically speaking. Once a dispute escalates to being about trust, capital, and corporate values, neither company can afford to just quietly back down without looking like a total hypocrite.
And this raises an important question about precedent. This collision between overwhelming legal force and carefully managed public trust is the defining tension of this case. This isn't just a squabble between two companies over a slashing line and an A. It is setting a structural precedent for how power will be wielded in the next era of enterprise technology.
Which brings us right to the ultimate takeaway for you, the listener. Why does this specific deep dive matter to your life, your business, or your understanding of tech? Well, whether you're building a company, designing a product, or just utilizing these incredible AI tools in your daily workflow, this case is a massive stress test for the future of the industry.
It really is.
It is going to determine whether massive frontier AI platforms, the titans of this new era, will be allowed to annex basic visual territory. We are talking about simple geometric shapes, the fundamental concept of a slash, the specific mathematical way a line animates across a screen. Can a company with billions in funding fence off those those fundamentals from specialized vertical companies that have spent years building their own customer trust and operational history?
It fundamentally tests whether the law will reward genuine source identification, meaning protecting real consumers from real deception in the marketplace, or if it will simply allow platform-scale companies to use their immense financial and legal resources to bully vertical specialists out of the visual landscape.
Because if they win,
If Anthropic wins this by effectively locking down basic geometric motion under trade dress, the chilling effect on design, branding, and innovation across the entire tech sector will be profound.
it really leaves us with a lingering, provocative thought, one that I want you to mull over long after this deep dive ends. If basic geometry and the fundamental mechanics of motion become heavily gated, aggressively litigated intellectual property in the AI sector, well, will the next generation of startups be forced to design visual identities that look entirely alien?
It's a real possibility.
Will future logos have to be convoluted, asymmetric messes just to avoid being sued into oblivion by the very frontier labs whose technology they rely on to exist? Think back to that bird in the sky from the beginning of our deep dive. If someone manages to copyright the concept of flight, everyone else is going to have to learn how to dig.
A fascinating, if slightly dystopian, thought for the future of design.
That's all for today's deep dive. Keep questioning the shapes around you, and we'll see you next time.